Objection. That's been asked and answered. Ask a different question, counselor. You want to know what this is and why some defense attorneys get really annoyed when I keep saying that? Come join me for a moment as I share you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, during a deposition, well, first of all, what is a deposition? It's a question and answer session given under oath. Now, this will happen when you bring a lawsuit. The defense lawyer who represents the people whom you have sued will have an opportunity to question you, to learn from you what happened in your own words and what injuries you have as a result of that. And now this takes place in our conference room. There's no judge there, there's no jury there, but the testimony that you give, the answers that you give to these questions, form the basis of your pretrial testimony. And by the way, this carries the same exact weight as if you are testifying at the time of trial. So now, when you're asked questions, invariably the defense attorney will ask a question to which they already just asked and got an answer. Maybe they change it up a little bit. Hey, Mr. Jones, were you taken by ambulance to the emergency room? Yes, I was. And when you were taken by ambulance to the emergency room, did they take you into a part of the hospital? Objection, asked and answered. Well, no, I didn't ask that way. I just wanted to know, and now they'll go ahead and argue with us. The problem is that some of these defense attorneys don't know how to ask proper questions. And it becomes very frustrating because we want them to ask a clean question. Now, what do I mean by a clean question? A question that's easy to understand, that's simple, so that I understand it, so my client understands it, so that the jury will understand it when it is presented at the time of trial. So if it's not clean, if it has a compound question where it asks for multiple things during the course of the trial, now the jury will get confused. Here's a great example of a question that was so ridiculous. My client went into the hospital and after an accident and now underwent surgery. And because of improper medical care, he required additional surgery to correct the first problem. So now the defense lawyer is asking him this question. It says, Mr. Jones, when you were brought into the hospital by ambulance, what part of the emergency room did you go into? He says, I don't know. I was just in a major serious accident. I have no idea. So the attorney says, well, was it in an area that had a curtain or was it in a room? He says, I don't know. Maybe it was in a room. And then she says, was it in a room with a door? And I said, a room with a door? Are you kidding me? That's the kind of question you're asking? And then she goes ahead and we begin arguing about this question, which I said was totally inappropriate. And I said, tell me how understanding whether or not he was in a room with a door affects your case or my claim at all. And she couldn't give me a straight answer. So now, a few minutes later, she comes back and says, well, when you were in the emergency room, did it have a room with a door? I said, objection, asked and answered. She said, no, I didn't ask that question. I didn't get an answer. And now again we start arguing over whether or not she asked that type of question or that specific question and whether or not the client gave that answer. And then it becomes a legal issue. And some people turn around and say, you know what, with both of you guys arguing, is that going to affect my case and how the attorney interprets my case and the value that they put on my case? The answer is no, it's not. Why? Because in all likelihood, the defense attorney is inexperienced, and the attorney who is questioning you typically is not the trial lawyer who's going to be trying your case. And everybody understands that the legal arguments that the attorneys get into are not going to decide the issue of the value of your case. They're not going to decide whether or not you are slightly more likely right than wrong, that what you are claiming is true. So even though you may hear the attorneys arguing over certain legal issues that arise during your question and answer session, when an attorney yells out, objection, asked and answered, what that means is, listen, counselor, you've already asked the question, and you've asked it multiple times, and you've already gotten an answer. So let's not ask the same thing over and over again, because at some point the answers will change, and now you're going to have a dirty transcript or transcript that asks the same question multiple times, and now you're getting multiple answers. And that's not going to help anybody. So why do I share this quick information with you? I share it with you just to help you understand how these types of cases work. You know, I do recognize you're watching this video because you want to see the beautiful scenery. No, you're watching it because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.